Thank you, Dean Beiruti, and we will just move right into the second part, or my part of the presentation. And I'm being asked to screen share, so I'm working on getting my PowerPoint set up real quick. My PowerPoint should be up now. So today I wanted to talk to and highlight some of the developing ag law topics and environmental law topics that have been happening over the past year. Again, for those that have come in maybe a little bit late, I'm Paul Geringer. I'm the Extension Legal Specialist here in the Department of Ag and Resource Economics. So we're going to go through a few things that have happened over the past year in this area. So I'll give you a little bit of a roadmap as we move through this. We're going to look at this workers' compensation decision that happened slightly at the end of last year that we talked a little bit about last year during this update. We'll talk about an air emissions decision here in the state. We'll talk a little bit about the National Environmental Protection Act and how USDA loan guarantees operate. We'll talk about an interesting nuisance case out of Texas that involved a couple of poultry farms. And I'll give a quick update and just hit some highlights on the dicamba, glyphosate, and broiler grower settlement. So we got, a lot packed in for the next 42 minutes. So, let's all just buckle in and get ready to go. So the first thing, kind of give an update on this poultry grower decision out of, I believe it's off the Lower Shore. So previously in 2019, we had this circuit court decision involving a Maryland farm poultry manager and an absentee poultry farm owner that had found the poultry farm manager to be a co-employee of not only this poultry farm owner, but also the poultry company Tyson. The case was a workers' compensation case. The poultry farm manager had developed illnesses that no longer allowed him to work on the farm. Because the farm owner was not paying workers' compensation insurance on him, it went to the state's unfunded workers' compensation fund. And when the fund looked at it, they tried to bring in Tyson and the poultry owner together and claim he was a co-employee. The circuit court, through a jury trial, found that the farm manager was only the employee of the poultry farm owner and not a co-employee of Tyson's. The Court of Appeals reversed that in 2019, said, no, it looks like there's enough level here to show that he's basically a co-employee. The issue really was the court looked at it and said, the farm manager, or this farm manager, is stepping in. He's being told what to do by Tyson. He's doing all this stuff Tyson told him to do to grow the chickens. The issue with that was the Court of Appeals never addressed, or the Court of Special Appeals never addressed this agency issue that we'll talk about here in just a second. So with that, around December of last year, the Court of Appeals overturned that decision. They looked at the record and they said the record was clear that a jury could believe from everything that went on in this case that the farm manager was not a joint employee of Tyson's. He was just an employee of the farm owner. They looked at the fact that basically Tyson really had no control over hiring this person. All they had told the new farm owner when he bought the farm from the existing owner was, because he didn't live in the area, he lived in Northern Virginia, and this farm was down in the Salisbury area. So there's a little bit of distance in between it. They had told him they needed somebody on the farm to be able to handle stuff, and he retained the existing farm manager who ended up having the workers' comp case. They had no control over firing him, and they had no control over his wages. They had very little control. All they were doing is he was stepping in the role of the farm owner and doing what the farm owner would have done and then told him to do if the farm owner had been more locally located in the area and not an absentee owner. The one thing to note here is, in the opinion, the Court of Appeals and Tyson agreed that there could actually be a case at some point where a farm manager on a poultry farm could actually be a joint employee of the poultry operation or the integrator. But the question always has been is like, when will that arise? The court couldn't think of situation, but both did agree this could happen at some point. So we'll have to wait and see if that ever does become an issue down the road. Now, let's talk about air emissions and CAFOs. And if there are questions, I'll get to them at the end. I can't see the question and answer or part right now, so I'll get to that at the end. I have left time for questions. So if you got questions, please put them in the chat box and we'll get to them slowly at the end. So air emissions and CAFOs, and this was an interesting decision that happened this year. So March of this year, and this is one that's got a lot of people asking questions and looking at some stuff that's going on in the state, and it's given us a little bit of national attention within the livestock industry. So March of this year, a Montgomery County Circuit Court held that the state had to take into account air emissions from animal feeding operations into the state's water discharge permit that is required for many of these operations. For those curious, first I'll answer the simple question as to why was this case decided in Montgomery County and not, in a county such as the Lower Eastern Shore or somewhere on the Eastern Shore. There might be more animal feeding operations with the poultry industry, or in a state or a part of the state with a few more dairies than Montgomery County. The issue with this is because this permit is statewide, it can be challenged basically in any state circuit court. So they picked Montgomery County for this, so that's why that decision comes out. I'm asked that question a lot, so I thought I'd address it first. So the court based this on a view of the word admit that's used in the statute. So if you look at the statutory language there, the court looked at it and said, they used a lot of synonyms for the word discharge, and they included the word admit, the General Assembly did, when they drafted the legislation back in the mid-'80s. Looking at it, the court said, look, admit can only be when you put stuff into the air. Now, you could also argue that when the General Assembly drafted the legislation, they put in every synonym possible for the word discharge just to make it clear that, this would be a discharge in the water. That's not, the court didn't handle the legislative issue that well, so we'll talk more about where that may happen here in a minute. But with this, they agreed with arguments from the plaintiffs in this case that the ammonia emissions that could come out of these exhaust fans with poultry operations and other operations would eventually come into covered water. So they would eventually go up into the atmosphere and come down and go into these covered waters that are covered, either waters of the state or waters of the U.S., depending on which way the wind flows would take it out of the exhaust fans. So it's worth noting in this too, if we look at this and look at some of the stuff, EPA has the view that this would not be a point source, but a non-point source. So EPA's view is once some of this goes up into the atmosphere, even though the exhaust fan would potentially be a point source under the Clean Air Act, it would be a non-point source pollution under the Clean Water Act, because then it would go down from a non-point into the water. They also looked at, in this circuit court decision, a past decision out of the 10th Circuit Court of Appeals that involved the incineration of weapons, old weapons, I believe it was weapons, that would potentially then go up. The emissions would go up and then come back down into waters of the U.S. covered in, I believe it was Colorado or Wyoming. And in that decision, the 10th Circuit said, no, they don't need to get a Clean Air Act or a Clean Water permit because they've already gone through the Clean Air Act to handle that issue. So now we don't have to take into account the Clean Water Act as well. The court's view in that decision was, the Clean Air Act is over here. It handles these air emissions. They have already gone through the process with the Clean Air Act. They don't have to also go through another process for the same emissions under the Clean Water Act. So there's some conflict here as to how would we view this, specifically related now with the Clean Air Act, where a lot of this is exempt from animal agriculture under the Clean Air Act. And should we now figure out or use the Clean Water Act as a way to, handle these emissions? It creates a lot of conflicts between the law two existing laws where we're trying to fit potentially air emissions now into the Clean Water Act, and how exactly will that be handled. So we're still waiting to see. This decision has been appealed, and last I checked with people involved, it was still in some of the pre-phases of that appeal, and hopefully there'll be a decision in 2022. It may be later, depending on what the process is once the oral arguments are scheduled on it. So if you're here next year, this will probably be discussed again next year. So let's talk a little bit about one last really Maryland case. And this involves this National Environmental Policy Act and USDA loan guarantees. It's always been an ongoing issue. It's had a lot of interesting things going on in it and developments, and we talked about some of them last year, and we'll talk about how they kind of play in together this year and work together. So I say over the years, we've seen this rise in challenges involving the NEPA review for USDA loan guarantees. And for those that don't know what NEPA is, in most cases, it requires federal agencies to at least do a review or an environmental assessment of federal actions that could potentially fall under the act. Not every federal action falls under the act, but many do, and it requires EPA, or it requires the agency to at least do some sort of federal review. NEPA is not regulated or is not managed by EPA. It's managed by another group that I'll talk about here in a minute, because that's where a lot of the challenges are coming from. We had seen this used in the early 2000s with success in Arkansas with a hog farm that was being placed on the Buffalo River. Farm Service Agency and the Small Business Administration had not done a proper NEPA review before granting these loan guarantees to build this hog farm when Farm Credit in Arkansas requested it. We had seen it used, and I believe it started around 2015 or 16 with a poultry farm in Caroline County. The poultry farm was established, and then there were challenges to the USDA review granting the loan guarantees. Now, I need you to keep that over to one side, and we need to talk about some of the changes. So in 2020, the Council on Environmental Quality, the group that's housed under the office of the president that actually handles NEPA, revised the NEPA regulations for the first time since 1978. And it did a lot of things, but the biggest thing it did potentially for agriculture is USDA loan guarantees are now excluded from it. According to CEQ, the idea was, look, we're never, the federal government really has no authority over these projects. They're just granting money that could potentially be spent later. They don't have control over the farming operation. They really have limited ability to dictate what's going on this farm. So without a level of control, there really is no reason to do this NEPA review. Now, fast forward to the case I'm talking about in Caroline County in 2021. Last year, we talked about sort of the CEQ changes and the dismissal of this case, or actually we hadn't gotten to dismissal. Dismissal was this year. I'm getting ahead of myself. So in 2021, the Federal Court of Appeals basically said, look, the environmental groups that were challenging this farm in Maryland actually had no standing to review or to challenge the NEPA review. And for the non-attorneys in the room, in order to go to court, you need to have standing. You need to be a party that if the court makes a decision and decides the outcome of the case, the court can actually do something to benefit you and resolve the case. In this case, the court looked at it and said, look, if we did what the environmental groups are asking for in this case, we would, found the review was lacking and the loan guarantees went away. There's nothing to say that this farm would actually go back and try to get the USDA loan guarantees. At the start, they had limited financial standing. Farm Credit was requesting that. Now they're different. They're in a different standing. They have a history of paying on time. They have a history, they have a better credit history. Would USDA require that at any point to come in? That's a good question. We, don't know the answer, and the court didn't want to look at it as a hypothetical and say, yeah, they would come in and still get the USDA loan guarantees. So the court also, the USDA had limited authority over this farm. All they were doing was granting money. They had no ability to control the operation. That was not a part of the loan guarantee process. They were just guaranteeing the loan for the lender if for some reason the borrower didn't pay. So I should back up, and I forgot to explain what a loan guarantee is for those that don't know. In many of these, USDA will issue, through Farm Service Agency, will issue loan guarantees. So if the borrower doesn't pay back the original bank, USDA will step in, pay the loan off to the bank, and then USDA becomes the loan holder, and they go after the borrower at that point and get the borrower to pay them back. So it's a way to limit the bank's financial risk. Now, with that said, in this case, they looked at it and said, look, there's no review. And then they looked at the review the state had done and said the state took into account, or not the state, USDA, through working through the state review process, took into account a lot of the things that, the state was looking at, that there was this ability to grant this, say the NEPA review was standing based on some of the outstanding things. Like there were certain issues with not having a nutrient management plan at the time when the review took place, but they knew a nutrient management plan would be in place because of the state process. So to the court, the NEPA review was, even if they found they were standing, it was still good. The other issue with this, and this came up in a concurrence to this opinion too, the court declined to touch this issue that involved CEQ, the Council on Environmental Quality, that actually did, the NEPA revisions. They declined to touch this issue because they had dealt with the NEPA review already. Or because they had dealt with the standing issue, they weren't going to look at this other issue. So the issue is, and this has been raised in a number of challenges to the revised changes to NEPA, the issue is CEQ is not an independent agency. So there's questions to, do they have the authority to issue binding regulations under the Administrative Procedures Act that lays out how regulations are put into place? There's a lot of ongoing challenges to this, so we don't know how that's going to play out. There's also been talk in the press from the Biden administration that they have expressed interest in re-looking at these rule changes that happened mid last year, in order to determine if it's something they want to keep in place. So it's not clear as to how this will play out. These may come back to be an ongoing issue where we have to look at how USDA loan guarantee reviews under NEPA will continue if the rules changes go away. So this may be continuing to be an issue. We just don't know at this point. Now on to one of the bigger cases that have been interesting to sort of follow for the year. So I want to give a little bit of timeline because this is an interesting poultry decision out of the state of Texas. In 2015, we have 231 acres purchased in Henderson County, Texas. The owner divides this farm and sets up two LLCs controlled by two different family members to establish two poultry farms on the property. The one thing to point out about the surrounding area around this poultry farm, or what would become a poultry farm, is it was owned by a bunch of people that had second homes that lived in either the Dallas or Houston area that like to go out in the country and live. So there was a lot of more wealthier folks living in this area who were there on the weekends and other issues. They end up, the guy who buys the farm and then divides it, contracts with Sanderson Poultry Farms to become a contract grower for Sanderson's. The property set up to contain two poultry farms separated by 300 feet with 8 barns per farm and 444,800 birds total on the farm together. So each farm would have half of that number of birds growing at any given point. By late 2016, these things become fully operational, and almost immediately the neighbors begin to complain about odors to the Texas Commission on Environmental Quality. TCEQ goes out and begins to give notice of violations to these two farms. I forget how many are actually issued. I have it in a later slide, to these two farms. And the neighbors eventually sue for nuisance. The neighbors actually go out and start keeping odor logs to determine, what they were able to not do and how long the odors lasted and what they ended up missing out on being able to do on their property because of these two farms. So what about the right to farm law? Because they sue for nuisance. In this case, it doesn't apply because there had been no change in condition that would allow it to apply. Oh, I went backwards. The farm arrived after the residences. The farm was there second. The residents were there first. So the right to farm law does not apply in this case. It's very clearly not going to apply based on how it's worded. The other thing to note out is, according to the Texas Commission on Environmental Quality standards, the farms combined had 2 times the number of birds likely to cause a nuisance and odor issue. And they had documented 62 odor complaints against the farms. And like I said before, they had kept logs determining the impact of all this on their daily lives. So it was very clear to the court this was a nuisance. So yeah, the court has found this clearly demonstrated, everything about it was a nuisance. And in the end, the Court of Appeals agreed with the trial court that there should be a permanent injunction granted against the owners of the farm and Sanderson Farms. So they cannot own or operate or be involved in a poultry farm on this property at any point. So Sanderson cannot find another owner at this point to come in and do this and take this farm over. It's pretty much now just going to be an empty farm. Currently, it's being appealed to the Texas Supreme Court. I have not heard what's happening there, but it has been an interesting case just based on the fact that if you look at some of the facts, this probably in Maryland would not happen just based on the fact that, the MDE is not going to allow you to get a permit for something that has 2 times the number of animal or livestock that would potentially cause, issues. And there's also going to be zoning and planning set into place for how some of this would go into effect to potentially prevent some of these issues from arising here or in parts of the region. So this has been an interesting case. And I like to give Texas people a hard time that, I would have expected something like this more likely here, but it seems like they're the ones with this interesting poultry decision that I have found fascinating to follow over the past year. So let's give a little bit of class action updates. So let's talk about the Roundup glyphosate litigation. Talked about this last year. We're probably going to be talking about it for a while. People have seen the ads on TV. We're now seeing other ads, and I think I have that in my wrap up for the year, talking about some of the new class actions we may be seeing. So in 2020, summer 2020, along with another settlement I'm going to talk about here in a minute, Bayer proposed a $10 billion settlement in the dicamba litigation, or not the dicamba, the glyphosate litigation. There would be $8 to $9 billion spent on settling current claims, and then another $1 billion set aside for the settlement of future claims. This settlement was initially rejected by the federal district court that was overseeing the federal class action. The main issue with it, and the main issue with most of the settlements, has been that Bayer, or the federal district court, does not like the fact that there is now this scientific panel involved in making the decisions on how we should award money to some of the victims in this case, in these class action lawsuits. They're taking that decision out of the hands of juries and leaving it up to a scientific panel. I would actually argue in some of this that we may actually want a scientific panel looking at this, that they may be in a better situation depending on how we set that panel up to make, some of these decisions, specifically if there's health people involved and other folks involved that may be able to make better decisions to figure out, what long-term impacts could be and what people may need in potential cases of medical expenses. They again tried to settle this early this year. That new settlement was now up to include $2 billion in future claims and established funds to pay between $5,000 to $220,000 for these future plaintiffs, and it would be available for up to 4 years. Again, it included a scientific panel, and that still raised concerns again in the settlement. May of this year, it was again rejected by the federal district court. Bayer has added, from what I can gather in the press, about $4.5 billion to cover costs that are ongoing with this settlement. They have been in trouble at various points over the year, it seems like, with the federal district court for some of their attempting to settle claims outside of the class action process. So there are some ongoing issues with this, and we'll have to wait and see how this kind of settles out in the end. Secondly, on this, at the same time as that first glyphosate settlement was announced, Bayer also announced a settlement in the dicamba litigation or class action litigation for about $400 million. That settlement was approved in December of last year. And basically it covered, any verified soybean yield damage from 2015 through 2020. The settlement process is pretty much closed. And if anybody actually did go through the process, we tried to get information out here that this was available for anybody that had potential dicamba drift damage on some of their soybean crops, that it was available, and they should look at the process on how to file a settlement. I don't know why that slide is still in there, but it should not be in there, and I'll have to delete it later. That's a problem on me not getting stuff deleted like I was specifically supposed to. But that settlement is now done for the most part. The other one to talk about, and this one's come out within the past couple of months, and I know a bunch of growers in the area have gotten claims notices on this and sheets, potentially with a lot of their grow histories on it. So if you did that, potentially we put out some information through the poultry extension team, through their newsletter, on what the settlement's about and some other stuff. So if you're interested in that, I can shoot you a link to that newsletter and you can look into that. It'll be a good background information on some of this, and some of it I'll cover right now. So this settlement was announced in a class action litigation that was filed in multiple states, but ended up in the Eastern District of Oklahoma against Tyson's and Purdue. The claims are that these companies, along with a whole host of other poultry companies, conspire to artificially lower grain payout or lower grower payout. And the argument is they conspired and utilized AgriStats as a way to look at how all this could be taken into account and how they could lower grower pay, even though AgriStats is anonymous. There's arguments that they're able to use it to conspire to do this. So forms have been mailed out, and you can get a lot of details at this broiler grower antitrust settlement.com. And I can't remember if on the next slide I didn't put the timeline in, but the settlement that's been announced has not been approved by the court yet. There's a fairness hearing early next year, I believe. And then if it does get approved through the fairness hearing, payouts will start happening sometime mid next year to late next year. So if you believe you're a part of this, you need to go in, and you can go to this website at broilergrowerantitrustsettlement.com. If you Google broiler antitrust settlement, you may come up with 2 or 3. This is the specific one for the Tyson Purdue one. Even if you didn't grow for them, those 2 companies, you may still be getting this just because of I didn't list out the 20 or so other companies that are alleged to be a part of the co-conspiracy that's a part of this. And if you grew for one of those companies, and they're all listed out on the website, you potentially could be a part of this as well. So you can go through and look at the process. I will point out, because I've been asked this question a few times, it is 100% anonymous. If you are a part of this, the companies will not know that you are a part of it. It will be handled through the plaintiff's attorneys, and the defendant, the broiler companies, will never know who was a part of this. So with our last few minutes, I'll probably leave about 10 minutes for questions. For those that have seen the commercials, we have potentially a new class action lawsuit being filed with plaintiff's attorneys seeking paraquat users to come forward for potential damages, for potential health issues that could be coming forward. There's also other ongoing challenges to the paraquat registration, so I threw that in there. We still have ongoing challenges to dicamba, the dicamba registration, and a few other pesticide registrations that I haven't put in here as well, but those are ongoing that we'll have to pay attention to. There has been very little movement on some of those this year. EPA and Army Corps of Engineers have announced they will no longer be enforcing the Navigable Waters Protection Rule and will develop a new definition in the future for how we will handle waters of the U.S. under the Clean Water Act. Basically, from what I can understand, we are now back at the world of Rapanos for a Clean Water Act jurisdiction. So if for those that remember how the Rapanos decision came down and the ultimate fun of trying to figure out where the majority was and where the dissent was in that, we are back in that world till EPA announces a new rule or Congress actually defines what waters of the U.S. would be, so we don't actually have to do a rule change every 4 to 8 years when we have a change in presidential administration, one party to the next. So I do this blog, and many people within ALEI contribute to it. It's at agris.umd.edu. If you want to go to it, you can sign up on the site. I believe you can still text to that number, and it will all sign you up automatically, and you'll get the updates whenever they come out weekly. If you enjoyed the sound of my voice minus my face, you can listen to me read some of them or talk to interesting people on my podcast at marylandagpodcast.org, or you can go to agris.umd.edu and just click on the podcast tab at the top, and it will throw everything up there. The final thing to throw out, and I'll leave this up for a second, so if folks want to scan the QR code, it should take you to the web address at the bottom. The Southern Extension Economists, which is a group of extension economists from the Southern region, are trying to put together a daily blog website that would provide crop information, trade information, policy information, a whole host of information. And on certain Fridays of each month, they would also include some ag law stuff as well. And I'm one of the technical editors for the ag law part of that, along with a couple other folks. But which hopefully will launch sometime early next year. We're doing a dry run right now to kind of figure out on the back end what issues need to be fixed before we actually go live. So we're hoping to launch that early next year for folks. But if you want to sign up and be a part of the email blast that will come out, everything's supposed to be around 250 words to 300 words, very short, relate to a chart or a picture that we can kind of lay out and explain to you real quickly, just an issue, and provide you with enough background information that you'll be able to go out to another source and then look at it. And now I will stop sharing my screen and take any questions and throw my contact info up there. And I believe I have stopped sharing my screen. What questions do you have? I see none so far, so I've answered everything perfectly. I see Colby's questions and I do not know the answer to that. I'll have to look into that and get back with you. The one thing I forgot to throw in there with glyphosate too is for those that didn't see the news, Bayer has removed or will be removing basically regular glyphosate from the consumer market, but only making it available to ag producers and others with licenses. But if you go into Home Depot or any of the home and garden stores, you will not be able, I believe starting sometime next year, not be able to buy glyphosate. It will be a different formulation, still called Roundup. You all are all welcome. I'm hoping people have questions. Or does everybody just want to go to break early? And I see the question from our next speaker. I do not believe there has been any movement since, I believe it was early in the Trump administration, Congress removed CAFO admissions from CERCLA and made them unreportable. But I know on the EPA end for the Clean Air Act, I have not seen any movement on that since really the Obama administration. I know related to, now I'm remembering what I think Shannon is asking about too. The data that EPA did collect under CERCLA and some of the air emissions stuff that they started under the second Bush administration, so I think it was around 2004, that data is slowly coming out. I believe the broiler stuff has come out recently and some particulate matter stuff came out last year, but EPA is on a slow roll to get that data out. I believe some federal district courts have put pressure on them that they need to get that data out after about 20 years. You're welcome for covering that. I covered the broiler settlement. It's any other questions? If you have questions, you can put them in the chat and I'll see them during the next panel, and I can also answer them during the next panel as well. But if there are no other questions, I'll let you go on break 5 minutes early, and I believe we will be back at 10 o'clock and get started with the next panel, which will be carbon markets.